All rise. The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Welcome to the Court of Appeals. I'm Valerie Zachary. To my right is Judge Toby Hampson. To my left is Judge Darren Jackson. To your right are our Clerk of Court, Jean Soar, and our Deputy Clerk, Roderick McFarland, who did a mighty fine job of opening court today. And to your left is our Deputy Marshal, Richard Remillard. On the calendar this morning is State versus Kwiagaye from Mecklenburg County. Let's go ahead and begin. Each of you will have 30 minutes for your argument, and of course, the appellant will argue first.
May it please the court, my name is Kirby Smith. I represent the defendant appellant, John Alexander Kwiagaye.
Kwiagaye?
Kwiagaye.
Thank you.
It is a Caribbean name.
Oh, okay, okay. Would you like to reserve time for rebuttal?
I would. 5 minutes, please.
Okay.
The facts in this case are fairly straightforward. In December of 2016, Christian Massey met a man he knew as Johnny LaFleur at the Charlotte Transit Center. They became friends over Facebook, speaking 2 to 3 times a month, he estimated. Mr. Massey, I should estimate it. It has culminated on February 23rd of 2018 when Mr. LaFleur invited Massey to come to Charlotte and chill with him for the night. Mr. Massey agreed. He drove into Charlotte. It was about an hour trip for him, and met Mr. LaFleur at 5501 Albright Avenue in Charlotte. This was a cul-de-sac, and Mr. Massey turned his car around and I think backed it into the driveway. He said Mr. LaFleur came up to the car and got in on the passenger side. At that point, Mr. Massey noticed a third gentleman, a black man wearing black clothes, a black hoodie, black bandana over his face, and carrying a gun, come out of the bushes towards his car. Mr. Massey tried to drive away, and I think he did drive away a little bit, but Mr. LaFleur punched him in the face and told him to stop the car. Mr. Massey did stop the car and tried to get out and run, but Mr. LaFleur and the third man grabbed Mr. Massey and pulled him back in the car and put him in the back seat. Mr. LaFleur was in the driver's seat. Mr. Massey was in the back seat with this third man. They were demanding money and rummaging through his car. Mr. Massey said, I have no money. And Mr. LaFleur tried to drive the car away, but Mr. Massey said, you can't drive my car. It's got a police tracking device on it. And at this point, Mr. LaFleur and the third man ran away. Mr. Massey waited a minute, got out of the car, went to a neighboring house, knocked on the door, and the police were called. The police were able to identify Kwiagaye as Mr. LaFleur based on the Facebook post. Mr. Kwiagaye was actually, I should say, warrants were issued for Kwiagaye for robbery with a dangerous weapon, conspiracy to commit robbery with a dangerous weapon, first-degree kidnapping, and assault. Now, it wasn't until February 28th when Kwiagaye was actually arrested. He was picked up by Charlotte police on an unrelated charge. I think they were traffic tickets, and at that time, the police realized Mr. Kwiagaye, had these unserved warrants relating to Mr. Massey from February 23rd. As a result, Kwiagaye was taken into custody. He was taken to the police department, taken to an interview room where he was questioned by Officer Barber with I think it's the Charlotte Mecklenburg Police Department now. Now at trial, Kwiagaye's attorney moved to suppress his statements made to Officer Barber. And Officer Barber's interview was recorded on a video. It was Exhibit 3. It should be in the record on appeal, but we really don't need to look at the record because the trial court made extensive findings of fact related to this interview. And as we know, findings of fact are binding on appeal if supported by competent evidence. So I'm just going to go over some of those findings of fact.
And just for clarification purposes, are you challenging any of those findings of fact as unsupported by the evidence, or claiming that there's any conflict in the evidence that needs to be resolved as far as those findings?
None that come to mind right now. I mean, no, sir. I have it in my brief, and I'm not doing it now. The judge found that at approximately 9 o'clock, Kwiagaye was served with the warrants, advised of his Miranda rights, and said he understood them. Now, this is according to the video the judge made these findings. The judge also noted that he could not, that Kwiagaye said something in response to his rights, but the judge could not understand what he said on the video. The second finding was the judge found that Officer Barber did understand something Kwiagaye had said. Officer Barber testified during the suppression hearing and said he couldn't make out what Kwiagaye said after he had been advised of his rights, but did hear Kwiagaye say something like attorney or lawyer.
Well, Mr. Smith, aren't these findings a little unclear or ambiguous? I mean, if I look at on page 46 of the findings of fact from the transcript, it says, it is unclear what Kwiagaye says to Officer Barber. It certainly seems implied that it's unclear from the recording.
You'll give me a second.
Okay. Sure.
On page 47,
At the bottom of page 46 is where I am. It is unclear what Kwiagaye says to Officer Barber.
yes, and that's my understanding is that's what the judge is saying he heard in the video himself. The next paragraph.
But it's a little, it seems to me that it may be ambiguous. What's your argument regarding that?
Well, my argument is that an ambiguous request for counsel made prior to waiving your right to counsel triggers the automatic protections of Miranda and Edwards, and that all questioning at that point should have ceased, but for questions designed to narrow questions designed to clarify whether or not Kwiagaye actually wanted an attorney. You'll see later, about 48 minutes later, and by the way, this interview wasn't an entire 48 minutes. It stopped and started along the way. Kwiagaye says, I said I needed an attorney. 2 minutes later, he says, when am I going to see my attorney? So the court, and I'm not disputing that finding of fact, Judge Zachary. What I'm saying is that is the judge's finding regarding what he heard on the video. The next paragraph.
Well, explain to me where you're getting that this is what this is the judge's finding based on what he heard on the video or DVD.
I think my recollection is that sort of at the close of the arguments by counsel, at one point the trial court actually kind of admonishes, I think it was the lawyer for the state, who was saying, I believe this is what the recording said, and the judge actually affirmatively says, well, I'm going to make my own determination as to
I'm sorry, I can't hear. Well, I couldn't understand what you were saying.
Well, my recollection of the transcript is at the close of the arguments by counsel, the judge actually sort of admonishes one of the lawyers and says, I don't need you to tell me what you believe is in that recording. You know, I saw it, I've heard it. I'll make my own determination when I make findings of fact.
I'll make my findings as to credibility.
Yeah, something like that.
Judge Zachary, if I could, I have trouble hearing you when you're not facing the microphone. I'm sorry. What I'm trying to get to is what really should be important here is what Officer Barber heard. Officer Barber testified, and the trial court found that he heard Kwiagaye say the word attorney.
Well, did the trial court find that, or is that just a recitation of what Officer Barber?
It's a finding on page 47.
Yeah, I'm looking at it, but it almost looks like a recitation to me. He was sworn, took the stand, and testified to the X. That, you know.
Yeah.
I mean, okay.
I mean, but it's under the findings of fact, and, you know, Officer Barber said he heard the word attorney. The judge is putting in the findings of fact. I should say there are no written findings of fact. These are all we've got. The judge finds as a fact that Officer Barber heard the word attorney. And It's Kwiagaye's position that this triggers the prophylactic, if that's the correct term, of Miranda, that all conversation should cease at that point. And except for, under the Edwards decision, narrow questions tailored to clarify the suspect's true intent. Does he want an attorney or not?
Is it your contention that the defendant's statement was ambiguous?
I actually heard that, I'm sorry.
Okay.
Yeah.
Oh,
I don't think it matters whether his statement is ambiguous or not, because under Miranda and Edwards, any indication you want a lawyer is sufficient. The problem comes in this case, and I'm going to jump ahead a little bit because I think that's where we're going, is the Davis decision. In Davis, we've got the first time where the Supreme Court of the United States brings up ambiguous requests for counsel and how they should be dealt with. And the question for this court really is whether or not Davis applies post-waiver or pre-waiver. It's Kwiagaye's contention that the Davis decision is limited to post-waiver analysis. If you read Davis, if you all know this, please stop me. Davis involved a Navy sailor who was being investigated for murder. He was advised of his rights by NCIS officers. He waived those rights. And an hour to 2 hours into the interview, Davis looks at the NCIS officers and says, "Do I need an attorney? Should I get an attorney?" And the officers say, "Well, that's up to you." And Davis continued on with the interrogation. As a result, on appeal, his attorneys, relying on Miranda and Edwards, said the conversation should have stopped right there because Davis gave an indication that he wanted counsel. The Supreme Court in Davis basically said no. Davis had waived his right to counsel. And so in order to invoke it after you've waived right to counsel, you must clearly and unambiguously, and some say unequivocally, invoke that right. Now, some courts have said that applies to pre-waiver as well. It has not come down, as far as I can tell, from the United States Supreme Court or the North Carolina Supreme Court. Now, I do cite in my brief a treatise, Lefebvre, Israel, criminal procedure, where they say Davis is a pre-waiver analysis. So, but based on those findings, I mean, what I'm saying today is it really doesn't matter whether it was ambiguous or not. Any indication that I want an attorney should stop the questioning except for the officer to say, well, what do you want? And in this case, listen to what Officer Barber said. The trial court found, again on page 47, that Officer Barber responded to Kwiagaye saying attorney by saying, let me get to it in a minute and I'll let you decide. That's how the officer responded to Kwiagaye saying whatever he said involving the word attorney. Let me get to it in a minute, I'll let you decide. The trial court basically found that that Kwiagaye did not unambiguously and unequivocally invoke his right to counsel. The trial court applied the Davis post-waiver standard or analysis, which I contend, or Kwiagaye I should say, contends is the incorrect standard. Just asking for counsel should trigger those automatic protections to come down.
Can the fact that the officers did not have great equipment render a defendant's invocation ambiguous?
Are you talking about the recording equipment? Mm-hmm. Quite frankly, I don't know. I don't know of any cases that discuss the recording equipment. To quote Donald Rumsfeld, I think you record the interview with the equipment you have, not the equipment you want. In this case, we have to take what we have. I don't think the state should be prejudiced by saying we didn't have the proper equipment, or the defendant should be harmed by saying it wasn't properly recorded. What we have here is a situation where someone says, attorney, in response, do you understand your rights? Do you want to invoke these rights? Do you want to talk to me? And he says something, says attorney. The officer says, we'll get to that, I'll get to that in a minute and you can decide. The problem is the officer never got back to it, and Kwiagaye never decided. I mean, it sounds like Kwiagaye later on had decided. He said, I want an attorney. But that is an ambiguous request. I'll grant you that. It is ambiguous. I'm sorry. This is, under our law, if a person's constitutional rights are violated, it's deemed prejudicial. And, it's, unless the state can show to this court, it's harmless beyond a reasonable doubt. This is North Carolina General Statute 15A-1443B.
Well, wasn't there a material conflict in the evidence at this motion to suppress hearing?
There was. Oh, conflict of evidence, you're talking about the alibi?
Well, no, I mean on the motion to suppress with regard to whether or not he invoked. The officer testified that he invoked. The attorneys were debating whether or not the statement was ambiguous or what he actually said. And of course, the recording equipment was no help in that regard.
Right.
So my question is, was there a material conflict of evidence at that motion to suppress hearing?
I don't think it was a material conflict of evidence. I think it was the question of what standard of law should be applied. Because the trial court was operating under the assumption that Kwiagaye had to unambiguously and unequivocally invoke his right to counsel, both prior to waiving and after waiving.
So so are you saying that the parties agreed on what the defendant said?
Oh, I'm sorry. I'm not saying they agreed. No, ma'am. Mm-hmm. What I'm saying, I don't recall the specific material disagreements. What I'm saying is the trial court's findings of fact should control simply because they're supported, in my opinion, by competent evidence. And I'm not looking beyond those facts.
Is it possible that your client actually made a better invocation than we can hear from the recording?
Yes, it's certainly possible. I mean, I could even go so far as to say probable. But, what we have is a situation where we have someone say something in response to, do you want an attorney? He says something and the word lawyer. And at that point, Officer Barber should not have said, we'll get to that in a moment, you can decide later. He should have said, what do you want to do? I mean, he should have clarified it under the Edwards standard.
And that seems like one of the things the trial court here was struggling with, right? The fact that, obviously the defendant did not testify at the suppression hearing, did not say, no, this is what I said.
That's right.
And so the trial court here is struggling with this sort of very limited record upon which to make findings in support of its suppression motion.
I agree. I agree wholeheartedly. But give me a second if you don't mind. I mean, I think the state's position is that Kwiagaye had to unambiguously and unequivocally invoke his right to counsel. I don't think that's the standard. The state has filed a memorandum of additional authority citing cases. They're all cases from this court. I would say they're distinguishable. Many of the cases are post-waiver analysis. Many of the cases deal with the issue of whether the person was in custody or not. We really don't have a case on point. I rely on the case of State v. Torres, where the North Carolina Supreme Court said any indication of a desire for counsel triggers the Miranda protections. Torres is an interesting case. Torres was actually out of Washington, North Carolina. I didn't know Ms. Torres. I don't know about the case, but it's close to where I live. Ms. Torres was in an abusive relationship, and she killed her husband. She got taken to the police department, and she was in custody. There was no doubt about that. And she says she's advised of her rights, and she looks at the police officer and says, do I need an attorney? And the police officer said, no, you don't need an attorney. And so she waived her rights and made a statement. She was convicted and sentenced to life in prison. The Supreme Court said, no, you can't do that. Simply saying, do I need an attorney is sufficient in Torres to trigger the Miranda protections. Now, what would have been the proper response in Torres? The officer could have clarified. Torres, as far as I'm concerned, has not been overruled. In fact, I don't think since State v. Murphy, a 1996 case, our Supreme Court has actually dealt with a waiver analysis like this since. Even in Murphy, though, Davis came out in 1994. State v. Murphy came out in 1996. That's another case where a person is asked whether or not they want a lawyer, and he says, I don't want to say anything, and the Supreme Court said that alone triggers the protections. So our Supreme Court, the North Carolina Supreme Court, has been very clear, in my opinion, that simply, ambiguously, equivocally, invoking the right to counsel is sufficient to stop the process. I do see I've got 5 minutes left before my rebuttal time starts. I'm happy to continue on with this argument. I don't know if you would like to hear about my second argument involving the conspiracy theory, the conspiracy charge, and the argument of acting in concert.
And one thing I would like to hear, just briefly, still on the first issue, is you've argued that the real issue here is the legal standard to be applied, but your colleague from the state has argued that that argument has effectively been waived by your trial counsel below, based on the fact that they sort of said, okay, here's fine, we'll go with that clear and unambiguous standard. We think we meet that standard, sort of conceding the standard in the trial court below.
Well, I disagree with that. This is not a trial strategy like, do we put the defendant on the stand or not? Do we offer something, do we offer evidence or not? This is the law. The law is what it is. Now, I contend trial counsel, yes, made a mistake. Said the standard is unambiguous and unequivocal. Invocation is what must be done, and argued that it had in fact been done by Kwiagaye. That's not, I say that's not the standard, and I think if I were to come before the court and not argue the correct standard of law, that would be disingenuous. When we see courts apply the wrong standard, the remedy is to say, well, that's the wrong standard, and remand it back and apply the right standard. We don't say, well, tough luck, you applied the wrong standard, so you got to live with that now. Maybe so when it comes to trial strategies, the defendant testifying. We don't let defendants come in and say, can I have a second chance? I should have testified. But this is a case where the court applied the wrong standard to the evidence or to the issue. And so the correct remedy, if I'm correct, is to remand this back to the trial court and say, all right, you used the wrong standard. Just use the right standard and let's see where we are. I do want to say one thing quickly about the conspiracy charge. This is an issue of first impression. And the trial court instructed the jury they could convict Kwiagaye of conspiracy to commit robbery with a dangerous weapon based on the theory of acting in concert. And I believe this is an issue of first impression here. It was discussed in a previous case that was unpublished that was attached to my brief, the name of which...
State v. Skinner that Judge Davis authored.
Yes.
And then I was going to ask you how you distinguish this case from Skinner.
Well, first and foremost, the issue is preserved. In Skinner, it was not preserved. This court reviewed it for plain error. In Skinner, here, trial counsel objected to the trial court instructing the jury on acting in concert and specifically said, I don't think acting in concert applies to conspiracy. Conspiracy, as we know, is a crime. It requires a specific agreement to commit a specific crime between two or more people. Acting in concert requires only a general plan or purpose to commit the crime. Oddly enough, it requires you to be present at the scene of the crime too. Conspiracy doesn't. But what that does is it effectively reduces the state's burden of proof. You can literally have a situation where there's no specific agreement to commit a crime, so you wouldn't have conspiracy, but all the jury needs to find is the person was present and there was just a general plan or purpose, and you can be convicted of conspiracy to commit the crime.
Do you agree that the evidence was sufficient to at least go to the jury on setting aside the acting in concert instruction for a second, but do you concede that the evidence was sufficient to go to the jury, surviving a motion to dismiss, on the conspiracy charge?
At this stage, I would, only because it's very rare to get direct evidence of a conspiracy. Our law books are full of examples of that. You know, it has to be generally inferred by circumstantial evidence. But here the jury found Kwiagaye not guilty of robbery with a dangerous weapon. They found him guilty of assault and second-degree kidnapping, so the jury said he was there, but they said he didn't participate in the robbery. And while this court has upheld inconsistent verdicts, it makes one wonder if the jury had not been instructed on acting in concert, would they have convicted Kwiagaye of conspiracy to commit a crime for which he was acquitted by the same jury?
Well, how do you respond to your opponent's argument that the jury instructions cured any problem there?
Well, this court, or the Supreme Court, I forget which, has said that when a jury is given two methods or theories to prosecute a case, when one of those is wrong and you can't determine under which one the person was convicted, the remedy is to reverse the conviction and remand it back for a new trial.
But isn't that like in a felony murder case where you're talking about the predicate felony for the felony murder?
I don't think I see the analogy, Judge Zachary.
Well, I'm asking if the Supreme Court case that you're talking about, and is it Pokalski? I can't remember the name of the case. But I'm assuming that, I guess I'm asking if that's...
Pulaski and Harris are the two Supreme Court cases, and I don't remember, I'm sorry to say.
Okay, because I think that's what they were, it seemed to me that they were talking about in a felony murder case where you've got two possible predicate felonies, and one was submitted to the jury in error, and you can't tell from the verdict sheet. It's like where it's an unclear verdict. Are you saying that we have an unclear verdict issue here?
Yes, because we can't tell under what theory the jury convicted Kwiagaye of conspiracy to commit robbery with a dangerous weapon. The problem is, in the Skinner case, this court said these instructions are sufficiently clear, but that was under the plain error analysis, meaning the instructions would have to be so wrong that it would have to result in a different verdict. Here, this is a de novo standard, and the question for this court simply is this a correct statement of the law? And here, I think it's clear it's not, because instructing the jury on acting in concert effectively reduces the bar for the state. And so I'm running out of time.
Yeah.
I'm going to reserve the rest of my time.
Well, do you have any further questions? Do you have any further questions? Okay, thank you. We'll reserve, you've got
Thank you.
4 minutes or so.
May it please the court, I'm Scott Beaver from the Department of Justice here representing the state of North Carolina. The state's position is that the judgments of the trial court should be affirmed. As to the first issue, the state's position is the trial court did not err in partially granting and partially denying the motion to dismiss. It appears from defense counsel's argument that we have an agreement on the trial court's findings of fact. It's the state's position that those findings, if supported by competent evidence, are binding on appeal, and that the conclusions of law must support the findings of fact. To move on to the legal standard, it is the state's position. I'm sorry, do you have a question? No.
Well, I do, but it's on something. Yeah, I'm kind of jumping ahead. Would you prefer to hear the question now, or?
Sure.
Okay. Is it your contention that there was a spirited debate at the hearing on the motion to suppress? Was that a debate on what the proper law was, or was that a debate as to some conflict in the evidence? Did the state and the defendant agree on the evidence? Was the trial court just applying the law?
The trial court, there was a conflict in that both parties agreed that, forgive me, the defense argued that the invocation of the right to counsel at 21-10-06 was unambiguous. Mm-hmm. The state disagreed. The court conducted its own review and determined that the statement was ambiguous, which then moves us to the applicable legal standard according to the state.
Okay.
And the state contends that this case is controlled by Davis v. United States. In Davis, the Supreme Court of the United States held that a suspect must unambiguously request counsel to warrant the cessation of questions and must articulate his desire to have counsel present sufficiently clearly that a reasonable police officer in the circumstances would understand that statement to be a request from an attorney.
And you would agree, though, that the facts of Davis involved post
They
waiver.
involve a post-waiver invocation.
Can you point us to something that has relevant to our courts, our state courts, applied that Davis ruling specifically to pre-waiver?
There is a case that I cited in my memorandum of additional authority, which was filed yesterday, that case is State v. Taylor, 247 NCAP 221 from 2016. In that case, during a police interview, the defendant asked to speak to his grandmother on the phone. Got the grandmother on the phone, and apparently the grandmother asked if the police had informed him of his right to talk to an attorney. The defendant responded, "An attorney? No, not yet. They didn't give me a chance yet." The defendant responded, "All right," as if he's listening to his grandmother's advice. The defendant then looked up at Detective Morse and asked, "Can I speak to an attorney?" The detective responded, "You can call one, absolutely." Defendant relayed that to the grandmother. "Yeah, they said I could call one." Detective then filled out a Miranda waiver form and advised defendant of his Miranda rights. Defendant refused to sign the form and explained that his grandmother told him not to sign anything. The detective then responded, "Okay, are you willing to talk to me today?" Defendant responded, "I will, but my grandmother said that I need an attorney or a lawyer present." The detective responded, "Well, okay, you're 19, you're an adult. That's really your decision whether or not you want to talk to me and kind of clear your name." Or the defendant then interrupted, "But I didn't do anything, so I'm willing to talk to you." The defendant then waived his rights. This court held that in context of the communication with the grandmother on the phone and with the detective, that because the detective asked the question during his telephone conversation with his grandmother after she raised the issue of his right to counsel, it is ambiguous whether the defendant was conveying his own desire to receive the assistance of counsel or whether he was merely relaying a question from his grandmother to Detective Morse. Applying Davis, this court held that the detective was not required to cease questioning because the defendant did not unambiguously convey that he wanted assistance of counsel. There's a second case that State v. Little, 203 NCAP 684, during a non-custodial interview, when the interview touched on a shooting, the defendant asked if he needed an attorney. The detective asked him, "I don't know, are you asking for one?" Defendant didn't reply. The defendant continued the interview and admitted to the shooting. When the detective asked for a statement, the defendant asked for an attorney and the interview ceased. This court held that the interview was non-custodial, so Miranda did not apply. But out of an abundance of caution, the court went ahead and addressed the invocation of counsel issue. And the court applied and held the statement, "Do I need an attorney?" to be ambiguous, applying Davis, and the detective could continue the interview. There are a couple of, and then there are, and this may, I can go back and explain a little more on Davis if you would like. But,
No, but it occurs to me that the Little court, at least to my recollection, did not cite Torres and did not deal with Torres in that context. Right. The other piece, I mean, isn't Little also distinguishable on the fact that there the police officer was essentially trying to ask those clarifying questions of, well, that's up to you. It's up to you whether you want to make that determination or not. And then the defendant affirmatively then made a waiver, clearly and unambiguously in that case. So, how do we deal with it here, where whatever was said, clearly the police officer understood it as an invocation of something. And and then affirmatively set aside the Miranda waiver and said, well, we'll get back to that. Let's see. I mean, that seems to me that's exactly the kind of prophylactic purpose of those Miranda rights in our Supreme Court's case law there. So,
Right. Well, I would submit that in Davis, the Davis court addressed the prophylaxis issue. It said, from Davis, we held in Miranda that a suspect is entitled to the assistance of counsel during custodial interrogation, even though the Constitution does not provide for such assistance. We held in Edwards that if the suspect invokes the right to counsel at any time, the police must immediately cease questioning him until an attorney is present. But we are unwilling to create a third layer of prophylaxis to prevent police from questioning when the suspect might want a lawyer. Unless the suspect actually requests an attorney, questioning may continue. And there are some other cases from this court that are, granted they are post-waiver cases, that discuss the Davis standard and apply it. There's a State v. Dix, in which the defendant was transported in custody to the Randolph County Jail. He had already expressed a desire to tell his story to the detective. He was asked by the detective to wait until they were back at the station, yet he gave a brief, unsolicited oral confession to the sergeant en route to the station. After being told about the confession, the detective expected to continue their former conversation and proceed with that statement that the defendant wanted to make. Thus, when the defendant remarked, I'm probably going to have a lawyer, to the detective, this court held the detective was understandably unsure of the purpose. In this case, the court held that in the context of Dix, the statement was ambiguous because no reasonable officer under the circumstances, which is the standard set forth in Davis, would have understood the defendant's words as an unambiguous actual request for an attorney, as opposed to a mere comment about the likelihood that defendant would eventually require the services of an attorney in this matter. It's interesting to note that the panel in Dix held, however, the rule enunciated in Davis that unless the in-custody suspect, quote, actually requests, unquote, an attorney, lawful questioning may continue, abrogated the then-majority rule discussed in Torres. So there's been some observation of Davis's effect on Torres by this court. The other case cited in the Memorandum of Additional Authority is Barnes, and I won't go into detail on the factual background of that, but what it did say was that where the defendant merely asked whether he needed an attorney, that ambiguous statement failed to meet what that panel called the, quote, bright line test established by Davis.
Excuse me.
Yes.
What evidence supports the trial court's finding that the defendant's statement was not unambiguous?
The evidence would be the interview and the trial court listening to it. There's also testimony from Officer Barber that he couldn't understand what the defendant was saying other than he heard the word attorney.
Well, first he testified, didn't he? From my review, my recollection of my review of the transcript, he testified that the defendant absolutely did not invoke at all, ever. And then on cross, I think he said attorney or lawyer or something. That the officer agreed that he said that. And so that's that's what you contend is the evidence for the finding that what his attempt to invoke was not unambiguous.
It would be the testimony of Officer Barber, the trial court's review of the video and the video itself.
Okay, so can inadequate equipment render a defendant's invocation ambiguous?
Again, I'm not familiar with case law on that subject. I don't see evidence in the record that the equipment was inadequate. I'm not sure what the legal standard for it.
Okay, okay.
Presumably, if one could not make out anything that would be said, I think that would, the video
Right.
didn't work.
Right.
So, and I don't know but in terms of what a sliding scale is to determine if it's inadequate or not,
Well, I guess I was looking at it as inadequate because you couldn't understand what the defendant was saying. But sometimes you can be, you can be together and not understand what someone's saying as well. So, your point's well taken.
Like when Judge Hampson isn't talking to the microphone.
Again, I think I've addressed the issues with Davis. Again, it is the state's position that Davis, even though the factual situation of Davis involved a post-waiver confession, Davis doesn't make that distinction. And the state's position on the reading of Davis is that the paramount focus of Davis is the nature of the invocation and that it must be unambiguous.
So you believe that Torres has been overruled, basically, or abrogated by the U.S. Supreme Court?
I believe so.
And you believe from the other cases you cited, Taylor and Little, that this court has actually adopted that, although our North Carolina Supreme Court has yet to weigh
Has
in.
yet to rule on it, correct.
Thank you.
I'm going to move on to the second issue, and that is the jury instruction on acting in concert. It is the state's position that there is no prejudicial error created by the trial courts giving the instruction on acting in concert. The basis of that is, as this court is aware, an error in jury instructions is prejudicial and requires a new trial only if there is a reasonable possibility that had the error in question not been committed, a different result would have been reached at the trial out of which the appeal arises. The jury was instructed on conspiracy and acting in concert. There is a plethora of circumstantial evidence in the case that would support a finding of a specific agreement necessary to support a conviction for conspiracy. We know that when Mr. Massey arrived on Albright Avenue, Mr. Kwiagaye came to his car. At that moment, a hidden man came out of the bushes and approached the car. And when the unknown man approached, the defendant in the car punched Mr. Massey. And that when he tried to exit the vehicle, they both dragged him back into the vehicle. It's not a great plan, but it's a specific plan to bring I think the jury can infer the plan was to bring Mr. Massey to Albright Avenue. Defendants, the other man, the skull called the other man, would come out, and between the two of them, they would commit a robbery of Mr. Massey. I'll speak very briefly about Skinner. Again, Skinner, the court didn't conclude its error. The court may conclude, if there's error in this case, the state would contend it's not prejudicial error. But the state thinks that the instructions here were sufficient in their totality to show the existence of an agreement.
How do you respond to your colleague's argument that, essentially where a jury is given sort of two theories upon which they can convict of a charge, the one that is valid and one that is not, we cannot simply just assume that they used the correct one, and therefore it would be prejudicial?
Right. I think, in in response to that statement of law, I would also make the observation that it's the defendant's burden to show prejudice, and I don't believe that's been accomplished here. Finally, as to the third issue, which involves the failure to submit the lesser included offense of second-degree kidnapping, of false imprisonment. There was a plethora of evidence to support each essential element of the verdict of second-degree kidnapping. As this court is aware, the elements are that there is an unlawful confinement, restraint, or removal done without the person upon who is confined, restrained, or removes consent, and that the defendant confined, restrained, or remove that person for the purpose of facilitating the defendant's commission of the robbery with a dangerous weapon. And fourth, that the confinement, restraint, and removal was a separate act independent of and apart from the robbery with the dangerous weapon. In this case, the evidence showed that when Mr. Massey arrived at Albright Avenue, he saw Mr. LaFleur sitting on the steps, and Mr. LaFleur got into the front seat where they talked for a moment, and he asked him to drive out of the neighborhood. At that point, Mr. Massey saw the unknown man with the hood and the gun. Mr. Massey tried to drive away, but Mr. LaFleur punched him in the face and told him to stop the car. Mr. Massey stopped the car, got out, and tried to run away. At this point, the defendant and the unknown man both grabbed Mr. Massey from behind, dragged him back into his car, and pushed him into the back seat. Once they got him into the car, they began going through the car looking for things, demanding money from him, told him he didn't have any money, and at that point, Mr. Massey was struck in the head with the unknown man's gun. Based on this showing, the state presented positive evidence to support each element of the kidnapping. Most importantly, that the confinement and restraint of Mr. Massey was done in facilitation of the defendant's and the unknown person's commission of the crime. And as the defendant says in his brief, the fact that he was not ultimately convicted of the robbery does not obviate the ability to convict him of the kidnapping. Just because the robbery wasn't successful doesn't mean that the kidnapping was not done, the second-degree kidnapping was not done to facilitate the unsuccessful robbery.
And the defendant's defense here was purely alibi. That's my recollection. He put on one alibi witness and rested the case. So there's no indication that any defense was premised on the concept that, well, yes, I was there, yes, I held him in my car, but there was never any intent or agreement to rob them. I mean, there was sort of no concession of those facts.
No, there was no concession.
I mean, I wonder if it's sort of akin to, almost the assertion of a self-defense. You can't invoke self-defense if you just claim it wasn't me, I didn't do it.
The state respectfully requests that the judgment of the trial court be affirmed. Thank you.
Do you have any further questions?
Any questions? I've got time to finish.
Thank you very much.
Thank you.
May it please the court, I got served, or I should say I received the state's memorandum of additional authority about 1 o'clock today. My computer system is down with malware, and my paralegal called me on the way here and said it arrived. Fortunately, though, I printed out every single case that cited Torres and Lexus. There are 30 cases. Judge Jackson, not one of them reverses Torres. Torres has been cited by the North Carolina Supreme Court in 1 or 2 cases since then, but nobody has explicitly overruled Torres. So as far as I'm concerned, Torres is the law of the land until the Supreme Court says otherwise. The vast majority of the other cases come from the Court of Appeals, and as the state conceded, basically deal with in-custody interrogations. A lot of the cases of those 30 are dealing with issues that aren't relevant to our case. And that's the way what happens. You get a Westlaw search when you search for a citation. You're going to get a lot of surplusage. So no, Torres, in my opinion, is still good law, and it has not been explicitly overruled. And I will admit some laziness on my part. I rely on Shepard's, and I've still got the little, not the green mark, it's a question mark, because there are issues related to it now, but it certainly has not been overruled according to Shepard's. Judge Zachary, about your question about the equipment, it dawned on me what you were trying to ask, I think, while I was listening to opposing counsel talk. If the equipment is inadequate, that could actually lead to ambiguous. It could make a situation ambiguous that otherwise might not be. The fact that we can't understand what Kwiagaye says on the video, it makes it ambiguous. The fact that Officer Barber was there and didn't really understand it, it makes it ambiguous. I think what's important here is to realize, I don't think Officer Barber, and this may be the cynic in me coming out, ever intended to offer an attorney to Kwiagaye. Remember, at 9:48, when Kwiagaye says, I said I needed an attorney, and at 9:50, when he said, when am I going to see my attorney, Officer Barber responds, you can call when you get downtown. That is the jail. And when Kwiagaye first mentioned an attorney at 9:10, Officer Barber looks at him and says, we'll get to that later, and he never did. And to my last argument, Judge Hampson, I think this can demonstrate the problem with conspiracy and acting in concert. If Kwiagaye and this third man agreed to rob Massey, then there's a conspiracy there. But if they said no weapons, you have a conspiracy to commit common law robbery. When the third man comes out of the bushes with a gun, Kwiagaye's in the car, okay? He goes through with it. There was a conspiracy to commit common law robbery, but Kwiagaye could be convicted under those facts of robbery with a dangerous weapon because he was present and there was a general plan or purpose. The general plan or purpose was to rob Massey. So what you can see is there is a situation where a person can be guilty of the substantive crime, but not guilty of the conspiracy because the plans change over time. And I think when you have a problem with the jury instructions, I don't think the burden's necessarily on the defendant to show, hey, there's a different result. I was prejudiced. I think the result is you change the jury instructions. You correctly instruct the jury, which is why I'm going to ask this court to please reverse Kwiagaye's convictions and remand this matter back to Mecklenburg County Superior Court for a new trial. Thank you.
Do you have any further questions? Do you have any further questions? Thank you. That concludes oral argument in this matter. I want to thank you both for your excellent oral arguments this afternoon. They'll be very helpful to us, give us plenty to think about. Mr. McFarland, if you'll.
All rise. This session of the North Carolina Court of Appeals is now adjourned.